Greetings, dear brothers and sisters in Christ. This is Mary Catherine May, and I'm your host on The House United. I'm so glad that you have joined us today. With me today, I have a friend of mine, a longtime friend, all the way from childhood, and her name is Julie Pawluk. She practices law in the Twin Cities in New Brighton with her two partners, and we're going to talk today to Julie about wills. Now, you might think that Christians and wills, I know there's a lot of talk about estate planning and the importance of it. I want to emphasize that because Christians as stewards of our money, we need to take care of this part also. So Julie, welcome to our program.
Oh,
Greetings.
Thank you.
And the first thing I want to ask you is to give us 4 brief definitions of just a few words that are the basics of estate planning. So the first one is, what is a will?
Well, very simply, a will is your statement of your wishes of how you want your estate to be divided after your death.
Okay. And what is an estate?
Well, your estate is any property that you own at the time of your death. Now, it is the property that you own in your name alone, because if you own things in joint tenancy with somebody else, then if you are the first one to die, the other party as the joint tenant, the surviving joint tenant, would then own the whole thing.
What is a joint tenant?
That is simply a form of ownership. When 2 or more people own something together as joint tenants, what that means is that eventually whoever is the survivor owns the whole thing.
So it could be husband and wife.
Yes.
It could be husband, wife, and children.
Could be.
It could be. So some of a legal...
Or even with a non-related party.
A non-related party. What is probate?
Well, probate is the process of transferring property from someone that died to someone else. And that is necessary anytime a person dies and owns property in their name alone.
Okay. And does probate refer to court, going to court?
Well, in most cases, yes, it does. But there are many forms of probate, from a very simple, what's called an informal probate, up to a very involved contested proceeding that is probably what most people think of when they hear the term probate.
Okay.
In reality, the informal, unsupervised probate is probably the more common.
Okay.
Power of attorney is a document that you have while you're alive. Okay, the will is dealing with what's going to happen after you die, where a power of attorney is a document that you have while you're alive that gives someone else the power to act on your behalf.
So a power of attorney ends when a person
absolutely, and that is something that a lot of people misunderstand.
Right. I didn't understand that either.
Right.
I thought a power of attorney is somebody that could handle things after you die, but that's not true.
No, after you die, the person that handles things is called the personal representative.
Personal representative.
And that person has to be appointed by the court to act as the personal representative.
What happens when you don't have a will?
Well, if you don't have a will, then Minnesota statutes, Minnesota law, provides for what happens to your estate. Now, in some cases, it may be fine. It may do exactly what you would have done even if you had drafted a will. But in some cases, it may turn out with a very different result. So, for instance, if you want to leave unequal gifts to your children, or if you want to exclude one of your children, or if you want to give some gifts to a charity or a friend, anything like that, that would not happen without having a will.
What happens if you die and have children, underage children under the legal 18, and you don't have a will? What happens to those children?
Well, if there are underage children, then someone is going to need to be appointed as their guardian.
And the court will do that?
The court will do that. Now,
not according to your wishes, so.
Well, if you have a will, you can include your wishes in the will that if you die and your children are still minors, you can name who you prefer to be the guardians. Okay. If you don't do that, then the court will make a decision which, again, could be very different than what your wishes were.
Not that we can get rid of all conflict in families with a will, but what can happen when there is no designation for things?
Well, you know, of course,
It can get pretty awful.
Yeah,
it can ruin
of course,
relationships.
it can ruin relationships. I've said this many times that when a person dies, it tends to bring out either the best or the worst in people. And unfortunately, we often see the situation where it brings out the worst in people. And where brothers and sisters, if they're the surviving heirs, may start fighting among themselves, that they felt that something should have gone to them, that mom or dad promised them something, but it was never included in the will, where there may have been, for instance, bank accounts that mom or dad held with one of the children, and it was mainly for convenience, but it wasn't stated in a will that was meant for convenience only. And in that case, then that account would go to that child whose name was on it. Okay.
I'd like to just talk a little bit. I'm going to share my situation again of how things can get a little complicated after the death of somebody.
Right.
So when my mother died, my brothers and I, two brothers and I, when my mother died, everything went to her husband, my stepfather, and the father of one of my brothers. And so when he passed away, then the estate, what remained after his death, went to all of us, except when the contents of the house, what was inside the house, went to my one brother, his son, my stepfather's son, because he was the remaining joint tenant at that time. And so when I wanted to go into the house to do things right, up and honest and above board, I needed to ask permission of my brother to go into the house because he owned what was inside the house, because it was his stepfather that passed away. People said, oh, just go in the house, and I didn't feel right about that. I wanted to do it the right way. But that's the kind of thing that a will can hopefully prevent, that type of thing.
Yes, a will should be able to prevent a lot of the arguments that the children might have otherwise.
So let's move on from that now. What makes a legal will in the state of Minnesota?
Well, in the state of Minnesota, a will has to be either entirely in the person's handwriting, or it has to be entirely typed. And then it has to be signed by the party making the will in front of two witnesses.
Notarized?
Now, it doesn't have to be notarized in order to be valid, but it's always a very good idea to have it notarized. Basically, by having it notarized, it makes it what's called a self-proved will. And what that means is that at the time in the future when that will is being probated, that the court doesn't have to hear from the witnesses at that time that, yes, they did in fact see the person sign the will. By having it notarized, it is accepted that they in fact did see the person sign.
So the only part that can be signed or handwritten with a will, the body of the will has to be handwritten or all typed. All handwritten or all typed.
Correct.
And then it needs to be signed with the two witnesses,
yes,
preferably notarized.
Exactly.
Right. Okay. So if you have a will that's partly typed and partly handwritten, and you think you're okay in the state of Minnesota,
you're not.
You're not, and you're not.
And
it's
so,
not valid.
and in fact,
not legal.
We see issues where someone has wanted to make some changes to their will, and so they just scratched something out and hand wrote the change in, and that will,
it's over.
It may not invalidate the entire will. The other portions of the will that were not written over might still be given effect.
You mean like the sections of things are labeled section 1?
Right. Okay. But the section, at least the section that was handwritten over, will be considered invalid.
Can you address a little bit about online wills and your experience?
I mean, these days with the internet, it's very easy to find all kinds of legal forms online. In some circumstances, it may be fine to use those kinds of forms, but in a lot of situations, it's not. And the problem is that you can find the form, but nobody's giving you any legal advice with that.
Right.
And so as you're filling it out, you may not understand the impact that any of the particular provisions might have.
Sometimes it's very hard to understand all this legal terminology.
Right. Well, and you know, we're trying to avoid all the legalese and make the documents readable and understandable to the, you know, the normal person.
What about downloading a will that is just a generic will without looking at specifics for the state of Minnesota? I'm talking about, you know, like if you download a general will, like you said, there's a lot of documents you can download.
Right, and so I don't know if, you know, if you might find a form that's generic and might not meet Minnesota requirements. Like for instance, I don't know if all states require 2 witnesses. So you might mistakenly download a form that only requires 1 witness, and then you'd have a problem. Then your will would not be valid.
And it might not tell you it has to be all handwritten or all typed.
Exactly.
Yeah.
Right.
Okay. Let's see. What kind of things would somebody put in a will that wouldn't work? For example, I'm talking like for an example, and maybe this is too broad of a question. Recently we were updating our wills, and I wanted to put some things in the will that really weren't a very good idea. And that's where a lawyer might come in handy also, you know, if you have a person that can advise you as you go through this. So what's something that you might want to put into a will that just wouldn't be a good idea? Maybe addressing the fact that you can write a memorandum, that you can have.
Sure. Well, yes, one area is dealing with personal property. Personal property is the stuff in your house, you know, the things that you own, your furniture, your household goods, your artwork, you know, that type of thing. You can make a mention in the will that you're going to have a separate memorandum dealing with all of those items, which is the way that I normally prefer to do it. The advantage of doing it that way is that as long as it's referenced in the will, it's given legal effect as though it was included actually in the body of the will.
So you'd make note of the memorandum.
Make note of the memorandum, and then you can do that memorandum on your own at any time.
And you can change it.
You can change it at any time without having to keep changing the will.
Right. Okay.
However, you can make specific gifts in the will of items of personal property, but then, you know, as you're going through life and your circumstances change, you might have gifts mentioned of items that no longer exist. Yeah. And that's the benefit of doing it by the separate list, is that you can change that list at any time. Another big consideration is when you are leaving things to children. If there are minor children, then you probably want to think about doing it differently than if the children were already adults, because you'll want to consider when would you want those children to have access to the funds.
And that's a question then that leads into the next question then, is what is a good age to do a will? And especially if, you know, if we're young and we're feeling healthy and invincible, and we felt that it was important when we did our first will, because my father passed away when I was 4 years old, to have provisions for how we wanted who to take care of our children, who to take care of the finances for our children. And so
that's a very good point, Mary, because I've had clients who have talked about a will and they say, well, but we don't have anything. And I say, well, do you have children? Well, yes. Well, then that's a very important thing. That's a very important thing to address. And even if you don't have much in the way of assets, just being able to state who you would want to take care of your children and who you would want to handle the finances for them is very important. And that alone should be enough to get you to consider doing a will.
I really, when our children were young, I did not want someone else to choose for me who would take care of our children. And Rick felt the same way. So how often is it a good idea to update your will?
Well, you should periodically just take a look at your wills and make sure that they still say what you want them to say. Also, anytime there's any change in your circumstances, whether it's that you've had additional children, that your assets have changed, that your living circumstances have somehow changed. Anytime there's a major life change, it's a good idea to take a look at the wills and see if they need any modification.
Okay, so then, so you don't have to go into a lawyer to update your will. You can just review, or not, you do have to go to update, excuse me. You don't have to review it, is what I mean. You don't have to go to a lawyer to at least look over your will and read it. Right.
We always suggest, and we normally will send out a reminder to people every 2 to 3 years just to take a look at it again. Okay. If it still says what you want, then there's no reason to update it. You know, in some cases, a person will do a will, and that will be fine for the rest of their lives. But in other cases, it won't. In other cases, if there are a lot of changes happening, and you know, and especially as your children get older.
Right, and you can take out the part, and then you have different provisions.
Right.
Maybe instead of who will be the guardian for your children, how you want your money distributed, or your resources distributed, maybe to children, maybe to grandchildren.
Exactly.
Different things like that. Okay, now I want to think about this, because I don't want to forget any questions. Okay, then what about the different types of wills? Say in relation to how your estate, how large your estate is, or those type of things.
Right. There are different types of wills, from very what's considered a simple will, up to very complicated, actually trusts, and a lot of things in between. So there are trust provisions that we can include when you have minor children. So for instance, if you have minor children and you want to state at what ages they would receive their portion of your estate, we can include trust provisions in the will. Or we could we could make mention in the will of what's called, or what's referred to as, an UTMA account, which stands for Uniform Transfers to Minors Act. Okay. So with an UTMA account, any monies for the children are going into an account that is then monitored by the person that you name as the custodian of the account. Okay. There are also wills that are geared towards avoiding your estate having to pay inheritance taxes.
So, and then okay, and is there a cutoff for for?
Well, in the Minnesota limit, and this is you're getting into a much more complicated area now.
Okay, just briefly then.
But just briefly, the Minnesota limit is $1 million for an individual. The federal limit is $5 million. Oh. So there may be, if you have an estate that's over $1 million, and you don't make provisions by, in your will, by using the trust provisions that are available, your estate might end up paying some Minnesota taxes, or Minnesota inheritance taxes, even if you're below the federal limit.
Okay. How do you, okay, and this is just a question, I told you I was going to stick to my list here, but I have a question for you that's not on here.
Sure.
Can you, again, briefly, tell us how somebody would figure out what is included in their estate? Home,
yeah, the estate includes anything that you own. So it could be your real estate, it could be your personal property, bank accounts.
Cars, expensive cars.
Absolutely.
Anything you own.
Life insurance proceeds, if they are being paid to your estate.
Okay.
What's not included in your estate is anything that you own jointly with somebody who survives you. Then they own that item. Also, if you have any accounts that are listed as payable on death or transfer on death, those transfer outside of the estate. So you don't, those assets are not included in your estate and do not need to be probated.
Okay. And how long does probate usually take? How long is I mean, I know it's different for everybody, but if we can kind of have an average of how long.
Sure. The probate process, once it's started, can be as little as maybe 6 months, up to well, several years, I guess, if there's some reason that it's complicated. You know, that could be that there are maybe there's real estate that needs to be sold and it takes a while to sell the real estate, or it could be that maybe the person is maybe they are inheriting an estate from someone else and they haven't received it yet. You know, there are many reasons.
This is a situation where if you've done a will online, this is a time when you really need to contact a lawyer, because all of these ins and outs and the complications.
Right, right.
What kind of things should a person look for with, you know, this basic information that we have? What kind of things should a person look for in a lawyer? Or, you know, somebody, what are we looking for? Because if we go out and we look in the phone book or we look on the directory on the internet and it says lawyer wills, how can we tell if we have someone that we feel we reasonably trust?
Yes. Well, you know, and of course
other than the fact that we've been friends forever, that I can trust my friend. Yeah.
Right. So. But, you know, and of course there are, you know, there are hundreds, if not thousands of attorneys that are very qualified to prepare wills for you. I think that probably the one very good way is to ask your own friends for referrals. You know, if they have an attorney that they've worked with that they've been very happy with. If not, it makes a lot of sense to maybe meet with a couple of different attorneys, have just an initial consultation with them.
Should that be free? Initial consultation?
Many attorneys offer a free initial consultation. That's something that you want to ask about when you're calling. But you can have an initial consultation with an attorney, talk to them a little about your situation, what it is you want to accomplish, and, you know, see how you feel about them. You know, I think that it's in choosing an attorney, it's often maybe not most important, but it's very important to find somebody that you feel comfortable working with.
Right. And we need to be upfront about things like fees. What is an unreasonable fee? You know, what's something because you need to ask about the money, the charges, and
you
the
do,
fees.
and an attorney should tell you up front what everything is going to cost. Often with wills, there will be a flat fee for a will. You know, for a simple will, you might be looking at something starting at $300 or $400 per person,
and which would come out of the estate then? No, this is preparing. This
is paid when you are preparing the will, right?
Do most lawyers ask for money up front, or if you don't have $300-400, are some lawyers willing to take payments?
Well, that's so individual. That's something that you'd need to ask them when you're, if you're in a kind of a tight financial situation, you certainly want to ask whether the
young
attorney
families
will take
might
payments.
be in a
right,
yeah.
Yes.
So, okay, boy, this is very good. Okay, let's talk about. I want to make sure I got all my questions here.
Right.
Okay, what are some common questions you get asked when people come in about wills?
Well,
estate planning would be more correct.
I guess one of the things that people ask is whether they have to leave everything equally to their children. And the thing to remember when you're doing your will is that it's your estate. You can do what you want with it.
Okay.
So unfortunately, there are family situations where a parent might not want to leave everything equally to all of their children. There might be a child who doesn't have a need for it. You know, if their own children are in different situations, you don't have to leave everything equally to your children. Also, if you have a child you want to exclude, you can do that, and you don't need to say, I leave, you know, John $1. You don't even need to say that. But you do need to say that you are specifically excluding him if you're doing that.
Okay, and this leads to another question, because this came up in a conversation we had privately, is when you are making out your memorandum and you're designating who should have what.
Right.
Some people just put it out on the table and they say, oh, they go around and draw names and then they go around and pick.
Right.
But if you want to leave things specifically to somebody, and you recommended that whoever is getting these things, say your children, your grandchildren, that they not know what's on the list ahead of time.
Well, that's something that people ask me is now who should get a copy of my will? And my advice is normally don't give it to anybody.
Because you as a lawyer keep a copy on.
I keep a copy, and you have the original and a copy, but because you have the right to change your will anytime you want to, I think it gets. I think
You're asking for trouble.
Well, I don't think it makes any sense to let your family or your friends, whoever you're leaving your estate to, I don't think it's advisable to let them know ahead of time, because if you later change your mind, then they might come in and try to challenge the new will because at one time you told them you were leaving them this or that. My opinion is that it isn't anybody else's business what you have in your will. That's your choice, and you have the right to change it anytime you want to.
Okay, okay, and then family conflict. Family conflict is sometimes going to happen, sometimes not. We've already talked about that. It can get really wicked.
Right.
It can get very, very bad. It can just end relationships, sometimes for a long period of time, sometimes forever, even among Christians. If you'll remember, Apostle and Paul, St. Paul and St. Barnabas had a falling out. And whatever that was about, we never found out. But there had been a disagreement, and they parted ways. Now, they might have parted ways disagreeing and respectfully, but even among Christians, when there's disagreement over an estate, it's not always fun and pretty. It can get just really ugly.
Right.
So as much preparation as you can do ahead of time.
Right. And Mary, that reminded me of something else that I would like to mention. And that is one of the things that you do not want to put into the will are funeral instructions. Because typically the will is never pulled out and even looked at until after the funeral is over. And when you talk about family conflict, making the funeral arrangements is an area that we often see a lot of conflict.
Yeah. Oh.
And so you don't want to put that into the will. You want to let your family know if you have special instructions, and there are ways to do that.
Very quickly, because we're going to run out of time.
Okay.
The importance of choosing a personal representative.
Oh, sure.
What type of person should that be?
Well, you want
not your best friend.
Not necessarily.
Now, don't choose it on emotion necessarily.
No, you want to choose it based on somebody who is familiar with all of your affairs, because you want them to know what they're looking for. You also want to choose somebody that's organized, because they're going to need to be able to gather all the information about your assets, about your debts, about your heirs. And
and now moving on quickly, because I'm thinking of these last few things
all
before we run out of time. Death certificates you need when somebody is deceased. Before you can do a lot of things with banks, accounts, anywhere, you need to have death certificates that will be issued, that you will receive. And what's a good number of death certificates for a family to get?
Oh boy, it just depends on how many different accounts are going to need to be.
At least 8 or 10.
I would say that's a reasonable number. You're going to probably need it for Social Security. You're going to need it for
banks.
Banks. Different.
Do you need it for life
accounts.
Insurance policies? Do you need a death certificate?
Life insurance policies. If there are, there may be retirement accounts that might have some kind of benefit. Investment accounts. That type of thing.
Okay. All right. We're just simply running out of time.
All right.
This has been wonderful. Thank you, Julie. I hope this has given you some really good information to go on. Maybe something that will get you thinking, something that will spark something that you haven't done before. Whether you should go online and download something without the benefit of legal advice, when to contact an attorney, the things that you need to ask and how you need to prepare. Thank you so much, Julie. God bless you.
Thank you, Mary. Thank you so much for having me.
Actually, like I said, Julie and I have been a long-time friends. We've known each other since childhood. Julie and I grew up at St. Michael's Ukrainian Orthodox Church, which is now St. Michael's and St. George's in Northeast Minneapolis.
Right.
Our mothers, our fathers knew each other. Our grandparents knew each other.
Right.
And so long-time relationship that is very dear to my heart. And I'm so grateful that you have come on the program today to share your legal advice.
Well, thank
you, Mary. So this is Julie Pawluk. She's a lawyer in the Twin Cities area practicing in Brighton. And thank you for joining us today. And remember, God always leaves his light on for you. Bye-bye.